Now, the parents of the Seminole-Heights murder suspect, they were in court today. Howell Donaldson Jr. and his wife Rosita say they should not be forced to testify that could eventually lead to their son's execution. But today, a judge told them they must cooperate. So the question is, will they? News reporter Eric Glasser was at today's hearing in Tampa, and it's going to be a tough call for the parents, Eric.
It sure is, Reggie. By the way, I want you to know that we're listening to Sarah over there, and this is that indictment that we were talking about. I just wanted to show it to people. It just came out from the clerk of the court's office. It's only 5 pages. It is not an arrest affidavit. It does not have a lot of detail about the evidence that's been collected. It simply is page after page of the grand jury's indictment saying that it holds Howell Donaldson III responsible for the murders of each of those victims in Seminole-Heights. Now, as to questioning his parents about that information, their attorney in court today tried to make an argument that said that no parent should be forced to give up information that might eventually lead to the execution of their own child. From an emotional standpoint, that is a winning argument. But from a strictly legal standpoint, it has not worked in the past, and it did not work again today.
Howell Donaldson Jr. and his wife Rosita entered the courthouse declining to answer questions, which is why they were here in the first place. Prosecutors have gotten the same cold shoulder from the couple, declining to offer testimony which might help convict their son, Howell Donaldson III, the suspect in the Seminole-Heights murders.
The Donaldsons have been devastated.
The couple's attorney, Ralph Fernandez, says there are several reasons the Donaldsons are declining to answer prosecutors' questions. Emotionally frazzled by a lack of sleep, even death threats. But the bottom line, he said, was that the Donaldsons don't think any parent should be forced to testify against their own child.
No matter how it's perceived, it's testimony that is being elicited to make a determination about the life or death for their son.
Prosecutors argue there's almost no case law supporting parental privilege, and in Florida, no law or precedent to support the Donaldsons' position. The couple, they say, is in a unique position to provide information about their son only they would know.
We are seeking testimony that would only be within Mr. and Mrs. Donaldson's access and knowledge.
So should the Donaldsons be legally compelled to testify?
And, is the state entitled to this? And the answer to that question, at least based on what the court has reviewed right now, the answer is yes. In fact,
Judge Margaret Taylor thinks so. She gave the Donaldsons until January 5th to cooperate with prosecutors.
Would you reconsider testifying now?
Asked as they left the building if they would do so, the couple still offered no answers. But their attorney says the discussions between the Donaldsons about their son is legally privileged. And if the Donaldsons want to appeal the parental issue all the way to the Supreme Court, Fernandez says he's ready.
So far, I haven't found anybody that has taken the personal angle and said, I would tell him everything to make sure my son was
within minutes. I can tell you of today's decision by the judge. The Donaldson's attorney in this case filed this motion, essentially an appeal of today's decision. It is now squarely on their shoulders, especially with this indictment now issued, as to whether or not they intend to cooperate with prosecutors in this case. They can choose to do so as of or before January 5th, but if they don't, they will have to be back inside this very same courthouse explaining why it is that they had now violated the judge's order. Live in Tampa, Eric Glasser, 10 News.